as far as I understand it, at least, that as long as you're disclosing these things and the board is approving them, it's not necessarily a legal issue. The bigger question here, though, is the ethical issues, right? The problem of self-dealing or, having a director's company do business with the nonprofit is certainly not one that's unique to your situation. This is something that has been a point of controversy for a number of groups. One that comes to mind for me is Wreaths Across America, which is responsible for laying wreaths at Arlington National Cemetery and other cemeteries across the country. They have been criticized for similar practice where they buy the wreaths from a company that is owned by the directors of the foundation. Now, they also haven't received any sort of legal reprimands for doing this. They disclose it as well. It's not something that they've stopped doing because of the criticism, and that's what it reminds me of, is that situation. And that can be something that people object to, right? Because the concern is, how can donors know that this contract is actually the best fit for the Second Amendment Foundation or the Citizens Citizens Committee for the right to keep and bear arms? And so what assurances can you offer to people who have that kind of concern about whether these are really the best deals, because you're on, both ends of them?
Well, first of all, the board of directors, our trustees, approves them. And since it's a related party transaction, I abstain. And they approve it, and it's matched against, it's in our minutes, which is also provided to the Attorney General as well for the last 40 years of our board meetings, that they're done at below market rates. So it saves the foundation money. And you probably wouldn't find anybody else out there doing it at a below market rate. I care about it. Every dollar we save that we don't have to spend is like a dollar we raised. And so it gets done that way. Our independent auditors look at it and review it and make sure that it's in the interest of the foundation as well. And again, we've been audited by the Internal Revenue Service several times over the years. That's the first thing they check, is any related party transaction. So related party transactions that favor and benefit the organization are a good thing. And I think we've proven that over the last 40 years. And anybody who's looked at it has come away with that. So it just doesn't. These charges now are really, by the Attorney General, are being done to try and hurt us, hurt our fundraising, hurt us from being able to spending time on our mission and accomplish the lawsuits we're filing. And it's not just us he's attacking, by the way. To be fair about it, he's done these same CID, civil investigative demands, to Davidson's and to RSR, trying to stop them from being able to ship product into the state of Washington and tie them up and cost them a fortune. And in fact, Davidson's and RSR just filed suit back against the Attorney General because they comply with his demands in the CIDs, which they're not complying. We complied because we felt we needed to be transparent. They've said no, because this is ridiculous. It would cost Davidson's over $1 million to comply with what the demands the AG has made. Again, he's picking on the whole firearms industry, any groups that support gun rights. He's going after all kinds of gun control measures to try and hurt gun owners in general. This is no secret that he's been an enemy of ours, and it's not exactly a fun relationship. But he's not supposed to misuse his office and do things of this nature. And when he does, we file a civil rights complaint against him, because this is total misuse of his office. It's not the first time he's done this, by the way. He just got stopped down unanimously by the state Supreme Court on a unanimous decision that he misused these same exact statutes that he's coming after us over to investigate us against another nonprofit here in the state of Washington as well. And got ruled unanimously. He also, part of our demands is we then asked through the public disclosure stuff for documents and information out of his files of any complaints against us and anything that might trigger an investigation. And they've been both slow to respond outside the guidelines of state law, as well as not give us documents. So in my deposition, when they deposed me, they provided a document that I'd never seen before that was a memo from somebody to somebody else that mentioned me in it, which should have been disclosed to us of our public records demands that they didn't even give us. And they can't claim a legal privilege because they actually provided it to us in a deposition. And then under state law, they broke the law and they owe us money for that, because there's a fine attached every day you didn't give it to us and every document you didn't hand over. He just got hit in Washington State Court for a $200,000 fine for doing that to another organization that he didn't agree with. And now he's had to admit there's 100,000 documents in another case that he didn't give either. I mean, the corruption running in our Attorney General's office is what really needs to be investigated.
Yeah, I mean, I think that's certainly a legitimate point to bring up about the Attorney General, and obviously he has a political motivation that is apparent for why he might want to pursue something like this against you. However, of course, that's also true in New York with Letitia James, the Democratic Attorney General there, and going after the NRA. And, at the same time, that doesn't necessarily mean that everything that has been reported on publicly about the NRA's issues is false, right? And so that's why I think it's important to, of course, have you come on and talk about this and give some answers to, these
Steven,
allegations.
That's why I'm glad to come on and give these answers and talk about it.
Yeah.
We have absolutely nothing to hide. The NRA didn't want to give Letitia James, information she demanded and asked for. We've given the AG every single thing he's asked for, because quite frankly, when we give it to him, he's going to choke on it. And I'm really kind of glad about that. And now that he's gone overboard, that's why we filed the suit, and we expect to get damages from it. One of the things that also was in the Wall Street Journal article that they got from the AG's office is there's on the related parties, which you've probably seen by looking at our tax returns. There's also something called the Service Bureau Association.
Yes.
Okay, and
There's
both the Wall Street
Merrill
Journal
Associates and the Service Bureau; those are the two.
Yeah. And the AG, is trying to make the argument here that the Service Bureau is me. Well, the Service Bureau is a nonprofit org set up like a farm co-op. It's a co-op that works for its members. The committee and the foundation are members. It does a lot of services for us. It provides our caging operations. It takes our accounting, our data processing. It runs our health insurance programs for the group so they can get better health insurance for our employees at lower prices, having more people in the same pool. It buys large things of equipment that both groups may want to use but couldn't afford to buy on their own. It bills out on a use basis at cost. It makes no money. It bills out at cost. And at the end of any year, if it shows the profit, it rebates it back to its members, the committee and the foundation, based on a patronage dividend, based on the percentages of usage of money they spent. So it's revenue neutral. It goes back to the groups. It was set up a long time ago, 40 years ago, by an accounting firm, Coopers & Lybrand, which at the time was one of the big 8 accounting firms, because groups can't commingle their money from a 501c3 and a 501c4. By having this in the middle, so to speak, you could share certain equipment, you could share certain employees, you could get certain things done at cheaper rates, and it was set up for that purpose. I have never gotten a penny from it, zero. But the Wall Street Journal.
Okay.
The Wall Street Journal and the Attorney General play this thing about what percentage of total dollars raised, quote unquote, went to related parties, as if it went to my pocket. I don't get anything from that at all. So they come up with like X percentage of dollars that we spend go to me. It doesn't go to me at all. Quite frankly, it's totally a fraudulent claim, and we proved it in court years ago. And we've been audited by the IRS with it. It would go crazy if that wasn't the case. And so for the AG to do this, and for the Wall Street Journal to not give the whole full story, and just basically raise issues without closing those issues, I found it to be a little appalling.